Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I do apologize for my tardiness, but, well, what do you do? How are you guys tonight? If you don't know, last night's show was cut a little bit short. And it was cut a little bit short by the internet gods, or whatever they are, who decided to just shut down. Like, my internet just shut down. Don't know why. It was really windy, cold, and rainy last night, so maybe that's why. Maybe it was because I was talking about the feds and the gay opery. Oh my goodness, who knows? I don't know. Oh my goodness, what is this? You know what that was? Gross. Anyway, so oh boy. So we've got some stuff to talk about tonight. I want to kind of wrap up last night's stream because I had funny stuff to talk about that wasn't neo-Nazis murdering people or like the uncomfortable idea that undercover federal agents potentially propagate violence in their attempts to infiltrate white supremacist groups. That the federal agents may even inadvertently push others towards that violent tendency by offering them support that wasn't otherwise there. It's that weird, like, sort of fine line between observance and entrapment. I talked about this a little bit with the... I just ate a peanut butter and jelly sandwich. I'm a grown man. I talked about this a little bit with the Jonathan Ledoux case, where we had this guy go to a place, and then we had a federal agent who made himself available as a target for Jonathan Ledoux to end up committing his criminal acts. And he did do the requisite criminal activity to be found guilty. He did that. He's admitted to it. It's in the affidavit. They have the logs. We got the texts. They've got all that. Absolutely. But there's a lingering philosophical question of, if that federal agent wasn't the one who answered the message, would he have had the opportunity to engage in the acts that he did? Maybe, maybe not. We don't know. Right? But the same thing with Adam Waffles or whatever is, if there's federal agents infiltrating white supremacist groups, presumably to infiltrate a white supremacist group, you have to act like a white supremacist. But you can't disclose that you're a Fed. So you have to take on the role. So does that influence... Does that add to an underlying air of support? And does that support then cause violence or cause criminal activity that might otherwise not have occurred? Like, if it's just four morons running around and there are no feds jumping in and encouraging them and offering more and more numbers, then maybe it stays as four morons running around. I mean, I'm exaggerating this a little bit, but it's an interesting question to me. So I was right in the middle of talking about that and getting to that point, and the internet just shut off. As far as what else I was going to say specifically, I have no idea. I was in kind of the live TV zone, right? So who knows? Who knows what else could be said about that? It's mildly interesting to me. There's some news stories that are out there. There's one of the stories I wanted to get to yesterday is a female scientist who just barely survived internet bullying. I don't know if you guys saw this, but she just barely made it through. And it's a real stunning success story. Very brave of this person. And to be fair to the person, I don't know that they particularly are driving the narrative, which of course this is what led to the bullying in the first place, was that people kind of misinterpreted a picture as a person driving a particular narrative, then they railed against the narrative, and then now there's a new narrative that this person survived the old narrative. Is really dumb. I'll do that in just a minute. We'll cover that as we let people filter in for this for the Vic content, which is coming up a little bit later in the show, not super late in the show, but yeah, I wanna talk about it. There's also the University of Connecticut and their report of some guys running around yelling racial slurs, and now Connecticut has charged these guys with a crime of talking. And that's a weird place to be. It's a weird place to be because we really need to be cautious and strongly guarded against criminal talking. Criminal talking should always be in relation to the actual commission of a crime, conveyance of a real threat of violence to a person, or something like that. Or fraud, those sorts of things. Criminal talking should not involve unpalatable word choices or insults or ridicule. It just shouldn't. You may not like insults, ridicule, or mean words. You may not like racial slurs. You may not like profanity. You may not like Christian rhetoric or anti-Christian rhetoric. It doesn't really matter, because people have a right to say these things, even if they're unpalatable. So we should take a look at that too, probably. Yeah, I guess. We'll do that. I just tried to breathe in tea that was left in my mouth. I thought I had swallowed it. Okay. We're going to go do those things in just a minute. And then what we're going to do after those, we're going to take a look at the Lemoine Letter to Judge Chupp. Talk about it. There's not a ton here. This is not a definitive thing. We'll talk about all these things. I'll kind of update you on the timeline for the Vic appeals and stuff like that. We'll go through all of that nonsense in the context of the letter and just in the greater context. That'll be one major topic. And then following that, there is a recent-ish decision. This was late September decision from the second Court of Appeals, which is the Fort Worth Court of Appeals. And it's the Court of Appeals which handles Judge Chupp's 141st District. And we get to see how they handled a TCPA case in September. Now, caveats to this, because I'm going to immediately get criticism from very wise internet peoples. And the caveat to this is a case that passed TCPA at the trial court level and then was overturned on appeals. Spoiler alert. So they actually got through TCPA. It was overturned on appeals. What I want to talk about with this case is how interesting it is that that they've decided that they got past the TCPA in the first place. We'll talk about why. But if anybody thought that Vic didn't have a case or didn't bring evidence or whatever they want to claim or argue, and you look at this case and say, well, this one got through at the trial court level, you start to understand that the trial court doesn't really have any idea how the TCPA works. And that's shown over and over again. Now, I personally have not found a single TCPA decision at the appellate level from Judge Chupp. I don't know if he's ever heard a TCPA case before. I have no idea. But I tried to find one and a brief search through the Court of Appeals to see if they've handled a case from Chupp with TCPA, just to see if I could find one that might give us some insight into what he was doing. either way, I was unable to, but we do have this case. It's very interesting to see the difference in trial court interpretations of the TCPA, to see what the appellate court says about how the TCPA works, how it's structured, and then we can take this and we can kind of try and make some determinations about the viability of Vic's appeal. Because the viability of the appeal is in question. It's always in question because you're coming in, when you're the appellant, you're coming in from a loss, right? Like there's no bones about that. You're appealing a decision that you found unfavorable and you believe was incorrect. But you still have to overcome the idea that somebody found it correct. And so you're going up to the trial, up to the appellate court, and you're asking them to look at what the trial court did and say that was wrong. And judges don't always want to do that. They don't always want to say another judge was incorrect. Sometimes they want to find a reason to preserve the decision. Who knows? I don't know that that's as normal in a TCPA case, especially because TCPA cases are reviewed, trying to say ruled and reviewed, are reviewed in a manner called de novo. It's a de novo review, which means of nothing. They start over. They look at the case in its entirety, and they're supposed to look at the entire record and make their determination based on the record and the arguments at appeals. They're not reviewing it within a specific set of guidelines or strictures as to what is being reviewed. It's the whole thing. It's a holistic review. And so that has some advantages and disadvantages. So it's you know, we can take a look at this. They reviewed this one, obviously always de novo. This was the opposite situation, but how they talk about it will give us some insight into how the Second Court of Appeals might look at this case. So I thought that might be an interesting way to close out the show. It's not the longest opinion. It's pretty long, but we'll get through it. Okay, we'll get through it. Let's see. So first, there are a couple of super chats that have come in early, and we'll take care of those real quick, and then we'll jump into the bullying stuff, and we'll jump into the weird, like, racial slur charges stuff. Okay? Oh, and I should say, someone from Adam Waffen or whatever, I think from Adam Waffen, it's I don't know, right? May have contacted me to have some discussions off the record. I don't know if they actually are. I don't know. Who knows what it could be? But I'm going to follow up on it and just see if there's legitimacy to it, if they'd be willing to say anything on or off the record. I have no idea. Obviously, I don't have any interest in the group's like function or whatever. I want to know particularly if they are actively trying to engage in acts that would be like violent, or if they're just limited to speech. That's what I'm curious about, because the way ProPublica classified them is clearly as a violent extremist group, and the way the Seattle police classify them is a group with propensity for violence and willing to and attempting to commit violent terroristic acts. So if I can talk to one and find out that that's all nonsense, that'd be an interesting thing to convey, their side of the story. I don't know. We'll see. Maybe they are, though. Maybe they're like, no, seriously, we bought a bunch of Zyklon and we're going for it. I don't know. I guess we'll find out. But okay. Other than that, working on a couple different shows coming up. I guess this is the last sort of housekeeping stuff. Working on a couple different shows. Working with lining up a financial advisor with the idea of having a discussion about, I guess, sort of investment strategies and asset protection strategies for people who are younger and maybe a little bit, maybe have some saved up money, like what they do with that, how they protect themselves with that. what sort of strategies there are for like prenups, what sort of strategies there are for sheltering assets without prenups, stuff like that is kind of on the menu. May bring in a Ty Beard to talk on that stream or in another stream about the same sort of topic, because there are different approaches to this, right? And financial advisors will have one way of doing things, lawyers will have another. Oftentimes they'll work together and try and work to shelter assets in that way. But I think that's an interesting topic, especially when I've had guests like Drexel on who talk about women only being out to take your stuff. And I know there are a bunch of guys out there that I've talked to who are very concerned about what happens if everything goes wrong. And there's some interesting thoughts, I guess, on the women's perspective on this. The women's perspective to marriage as an investment versus the men's, I guess, perspective of marriage as an investment. There are competing and conflicting things going on here. If we look at this from a sort of typical, a very watered down sort of view, guys tend to not be successful early in life, but then grow in their success later in life. Women, for better or worse, tend to have maximized attractiveness early in life, and then that we should say objectively depreciates. I don't know how to say that, but the idea is that men typically are attracted to younger people with a certain set of features, and as they grow older, that wanes. So you've got two competing arcs of value, and so the idea behind a prenup is interesting in the fact that this sort of view means that women are performing up front with their value to the relationship, and men are expected to perform later. But if there's a way for men to get out when those performance lines cross, then that maximizes the investment in one way. And that's weird. That's a thing that we have to realize is part of some considerations, especially high net worth individuals are considering that because, or people with propensity for high net worth. And there's other performance. I'm not just talking about sexual here, but there's other performance, like, for example, providing comfort and companionship and even bearing children and stuff while a person is in school, say a doctor, when their income is low but expected to increase dramatically at a certain point. Like there's a bunch of value that happens in the upfront part of that relationship that doesn't translate to later down the road from one side to the other. So talking about those considerations, talking about prenups in that way, and giving kind of both sides of that argument, maybe interesting, maybe not. I don't know. You'll have to determine if that's interesting. That said, other streams we're working on. I'm going to work on setting something up with Amazing Lucas. I think he'd be a great interview to have. And then, I've got another lawyer who has a really interesting case that I would love to talk about, but until I get confirmation from him, I'm not going to announce who it is. But I think many of you are familiar with one of the cases that he's got going. But yeah, and then I'll be looking to connect up with Phil from the Dollhouse, who apparently sells the sex dolls, because the sex doll industry is very intriguing and a different sort of burgeoning field of law, and burgeoning not only in the pants, but in reality. Okay, Freighter J says, I just want to hear Lemoine quote Robody Girly Man. We die, though our war is eternal. We are doomed, but we walk in darkness. We are forgotten, yet the future is our gift to humanity. Coolman229 says, hey Nick, I heard that a new Funimation dub has a misogynistic guy calling a girl sweet cheeks when she gets mad about it. Are you influencing these dubs by pissing them off? Oh man, I hope so. Are they that butthurt about you? They might, I don't know. They might be. Chris, I don't want to take any credit for that. That's all their creative juices. Chris Kennedy says, hey Nick, did you hear about Steven Crowder exposing YouTube, trying to silence Tulsi Gabbard? Scary stuff. No, I haven't heard anything about that. There was some discussion about Tulsi Gabbard in my Discord the other day. I don't really care. So wasn't super involved in that discussion, but I did not hear anything about Crowder talking about it. But she's she's like a former service member, attractive Democrat female candidate, right? Well, good luck. Good luck, lady. You got an old white guy with really white hair, and then another one named Hillary Clinton. Also an old white guy with really white hair that you've got to compete against. And if you're young and attractive and accomplished, watch out. Watch out. Okay. Let's get... Oh, I got to get this... Let me see if I can get this thing pulled up here. What do we got? It was the... see if we can find... No. Oh my goodness. So this is a story that started back in April. Wait, what's her name? Hold on. Katie Bauman. On trolling and teamwork. Oh my god. No. I don't want a video. Oh, goodness. Let's see. News. Where was it? Okay. Well, I'll pull this up. I don't want that. Hold on, let me mute the audio here. I'll get through the ad, and we may pull this thing up in just a second. Long story short, if you guys, I don't know if you follow astronomy news. I don't, except that when astronomy news occurs, which is literally constantly, I get a billion stupid things in my recommended Google stuff. I don't know why. I don't actually follow astronomy news, but Google wants me to know about it. So a while back, they filmed, for the first time ever, they got an optical image of a accretion disk surrounding a black hole. All right. And it was big news. It's this blurry thing from an elliptical galaxy that's far away and situated just right. And they used this cool process called interferometry, I believe. Someone's going to correct me on that. Someone is going to correct me on interferometry being maybe that's just what it is with radio transmission. I don't know. But the long story short is the resolution of your telescope is limited by the size of the receptive dish or mirror that you're using. One way to increase, and it's a math function about the diameter of it specifically. One way to increase the diameter is by using something called interferometry. And interferometry is where you take pictures at different places and then string those together to increase the diameter of your mirror, so to speak. So what they did was they combined a bunch of pictures from specific telescopes pointed all at the same spot from all over the Earth over a really long period. And that then increases the diameter of the mirror that they're using to gather all the light effectively. And by making that composite image, they're able to get this really hard to take picture of a really far away thing that's really hard to see. All right. So that being said, they did this, but to compile all these images, they had to write like an algorithm. And there's a big team of people involved in this. And this one chick, Katie Bowman, is one of the computer scientists who worked on it. And let me pull up the thing. So here's the picture. Here's a picture. This is her, like, seeing yeah, so she was a key leader on the team that captured the first ever image of a black hole earlier this year. Celebratory image she posted online ended up on the receiving end of misogynistic trolling, but her team rallied round to support her. Okay, so this is it. All right, now we're gonna see the misogynistic trolling in just a second. All right, we're gonna see now her team rallied around to support her. So I'm gonna pull up. Let me put on my headphones, and then I'll follow along on the video with you guys. So let's take a look. It's BBC, so prepare yourself for dramatic music. How dramatic can you get? Do you remember her?
Hi, my name is Katie Bauman. I'm an assistant professor at Caltech. I was part of this amazing international collaboration called the Event Horizon Telescope.
Okay, she's a key leader, captured the first ever image of a black hole. Now, I mean, it's not really the first ever image of a black hole, but it's the first ever image of like what they're looking for here. This is a clickbaity way that science is doing things lately, where they're saying first time ever captured this, first time ever observed this, first time that. It's not really what it is. But this is a monumental sort of achievement that they put together, that they got what they were after, and that's the important part. So, but I just wanted to, when I brought up this story around an astronomer, I got griped at. So
taking an image of a black hole is a really hard task. Black holes are really, really far away from us. You actually need a really big telescope,
really big,
the size of the Earth.
See? A virtual super telescope.
But because of the fact that we only have telescopes at a few locations, there's a lot of holes in the data.
Big holes. Black holes.
We design algorithms to take the limited data that we have and fill in the missing information with ones that seem most reasonable.
So let's just point out though that that's not then an actual image of the black hole, right? Like, can we, I mean, again, not criticizing the achievement. They set out what they were after, but it's not really an optical image if you don't have an optical image, but you're filling it in with data from unexisting things. It's a minor distinction, but I just find it funny because, like, it's a first ever image of a black hole. Well, with an algorithm that filled in the parts that we didn't see.
Imagine every measurement that we make is kind of like hearing one note in a song.
Yeah.
So watching the black hole with the Event Horizon Telescope is a little bit like listening to a song being played on a piano that it has a lot of broken keys. You can still make out what the underlying song is.
Can you? Can you really, though? I don't know if that's true. You get like every 12th note, you just automatically can figure out what the song is? I mean, you could probably come up with a lot of songs. They listened well.
So when we got the data, we were so excited at what we were seeing, and we started snapping photos of each other.
Okay. Hold on, I gotta go back. We gotta make sure and get the memes, because remember, it's the toxic masculine memes or whatever. Not everyone was thrilled by Katie's newfound fame. Woman whom media claims created black hole image contributed 0.26 of code. 0.26% of code. So there you go. That's one of the memes. Here's the next one. This is Andrew Chale. This is Reddit, which, or GitHub. No, this looks like Reddit. Yeah, r/pics. Good job, Reddit. This is, why did they blur it out up here when you can clearly read it? This is Andrew Chale. He wrote 850,000 of the 900 lines of code that were written in the historic black hole image algorithm. Good job to that guy. That's a lot of code. Trolls accused her of taking credit for male colleagues' work. Uh-oh. But the scientific community came to her defense. Look, they both worked on it. They're sitting next to each other at this airport. See?
Getting the attention that I got, it was I was not expecting it. At first, I was really...
A woman wanting sole credit for the work of over 200. Now, this one's unfair. This one's unfair, I think. I don't think she did any of that, but maybe. I saw, like, other media publications doing that, but here we go. And if you notice right here, look, here it is, the woman behind first black hole image. Do you think the BBC had something to do with driving this narrative? I don't know how the BBC might have something to do with convincing people that this was the one person in charge of the whole thing. How would people come to this conclusion that she was trying to take the work that someone else did? I don't know. Oh my goodness. Why would these online trolls think that that was happening? You literally said it in your headline, you morons. Okay. See this one. Not enough of her name. That's the only name I've seen floating around. So here's why, right? Despite making 0.26% of the code, a woman makes 100% of the credit. Okay, hold on. I need to... Oh, no. I gotta make sure I got the Streamlabs pulled up here. Oh, God, that was funny. Thank you for that. Okay. Goodness gracious. Okay, let's get back to this. I was really taken aback by it.
Really taken aback by it. But at the same time, I do think it is important that we highlight the women in these roles, but we still need to get more women interested and involved and feel comfortable with their environments.
Good job doing that. Good job. Actually, BBC, you did a great job by pointing out, perhaps inadvertently, I'm sure, that one woman was responsible for the black hole image. That was a collective effort that you really made, and then subjecting her to criticism for your narrative is definitely a way to get a bunch more women into the field and highlight their achievements. Because you know what really I think everybody wants? Everybody wants the BBC to run a stupid narrative and then them take the heat for what the BBC and other news publications did. That's how you definitely convince more people to do these things.
I've had a 4-year-old girl come up to me and tell me about the black hole and becoming a scientist, and that is just amazing to hear. And I hope that this work that we did helps to inspire the next generation of young scientists.
I want to point out that in this video, it's supposed to talk about trolling and teamwork, and she doesn't really talk about trolling or teamwork at all in the video. Maybe this is a BBC problem. Like, maybe they just don't know how to functionally write news stories. I think that might be the issue. Because she doesn't really discuss the trolling. She just said she was taken aback by it. She doesn't talk about the teamwork really at all. It's not her fault, right? They're the ones asking the questions and then clipping out her answers. But it's really, 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 really hard to really take far away from pictures of really, really black holes. I got that, but I didn't see anything about the trolling and the teamwork. But her team rallied around to support her. That was literally one scroll by of a Twitter thread. Thank you, British Broadcasting Channel. Huh. You've shown us how the trolls were defeated. They didn't even show how the trolls were really effective. But, oh, God. So anyway, that's the story. I just kind of wanted to make fun of how ridiculous this little bit was. That was not top shelf journalism, in my opinion. Let's find this Connecticut story, racists. This'll get it. All right. Oh my God. Here we gotta get a couple of these stories. Okay, so we've got Vox.com, paragon of journalism. We've got Washington Post. That'll be great. All right. Oh, no. Okay, there's no sound coming through. That's good. I just want to pause this stupid thing. Go away. All right, let's see if we can find this 11-second video. Oh, we'll watch it on my banned Twitter account. Perfect. There we go. No, not that. Oh my goodness, I'm sorry. Okay. We have it. All right. Don't ask why there's like a phone screen here. I don't know. Listen, okay? Not everybody, you online trolls picking on me for my inability to use technology like a functional human being. How dare you? How dare you? Listen, there were 200 people involved in pressing that button incorrectly, and I only wrote 0.26% of the code that made it run the intro there. So how dare you? Don't put all that on me. All right, let's take a quick look. So here's Vox. White UConn students were arrested for shouting the N-word. Black students say the incident is part of a larger problem. Students say the university needs to do a lot more to address a deeper culture of racism on campus. We all bleed the same. If you're not with us, you're against us. So that's good. That's inclusive. For more than a week, students at UConn have been outraged over a recent video showing a small group of white students walking on campus yelling the N-word. As anger over the incident has grown, the black students have stressed that the controversy highlights a long-standing set of problems on their campus. Racist acts are continuing to alienate the school's black students, and UConn's administration is not doing enough to punish students for it. So there you go. What you do is when, as an adult, when you're confronted with something uncomfortable, you want to punish you want to go to an authority to punish the person rather than addressing it on your own. Bigotry says, what a waste of money. They wanted to photograph a black hole that destroys everything in its path. They just could have paid Zoe Quinn $20. Oh my goodness. All right. So the current controversy stems from an 11-second video that spread online. After it was recorded by a black UConn student sitting in his apartment. In the video, 3 students are seen walking across the parking lot of school's Chester Oaks apartment complex at night. 2 of them can be heard saying the N-word multiple times in quick succession, saying the term louder with each repetition. Are they just playing the penis game but more edgy? Do you guys remember the penis game? Did you guys? Maybe you don't. I guess if you never did that, you wouldn't remember it. But are you aware of the penis game? Like where like someone starts off quietly saying penis, and then it gets louder and louder until eventually someone has to yell it out. Like typically at a school or something like that. Let's take a look at this. So here's the UConn branch of the NAACP. If you have any information about this racist recording at UConn, please email NAACPUConn1909@gmail.com. We will not tolerate racist behavior. And then it is a dark hand turning white. Now see, this looks racist, right? They're going from the darkest shade of fist to the lightest shade. Are they whitewashing? Like what's going on here? I don't trust the NAACP. Take a look. That's it? That? Wait, what? Hold on. Hold up. Arrested! They're arrested! They're actually arrested for this! They're not even talking to someone else. They're talking back and forth. Oh my god. What? They're arrested? Criminal charges. Oh my goodness. I heard saying the N-word multiple times in quick succession, saying the term louder. They didn't even yell. Oh my gosh. I'm louder in my own office than those guys were. Oh god. On Monday, the same day, they held a march and rally over the incident. They had a march and a rally over two guys being edgy in a parking lot. They weren't like following someone, calling them the racial slur. They weren't spray painting it on like a lunch tray or something. These are just two dopes in a parking lot. Campus police arrested two of the students in the video, identifying them as Jared Corral and Ryan Mukaj. According to the Washington Post, well, let's just go back to the Washington Post story here. 3 people walking through a dimly lit parking lot near University of Connecticut student apartment complex probably didn't know they were being watched. Then why should they be arrested? Why should they be arrested? They didn't know they were being watched. They weren't disrupting people. As the trio crossed in front of an open window, repeatedly saying the N-word louder and louder. A person inside wasn't just observing. They were recording. Now, university officials say an investigation into the 11-second video, which started to widely circulate on social media earlier this month, has prompted campus police to arrest and charge 2 students Monday with violating a Connecticut hate crime statute. We're going to pull it up. We'll pull it up in just a second. Jared Corral and Ryan Mukaj, both 21, described by the police as white. That's an interesting statement, isn't it? Described by police as white. I saw a picture of these guys somewhere. Where are they? I just saw a picture of them. Saw their little mugshots. Where are they? Oh. We'll find it in a minute. Let's see. We're charged with ridicule on account of creed, religion, color, denomination, nationality, or race. The misdemeanor charge is punishable by a maximum of 30 days in jail, a fine of up to $50 or both, according to state law. Police found that the third person in the video did not participate in saying the racial slur. But, whoa, wait a minute. This guy was definitely an accessory to the attempted murder by words of nobody around. He was an accomplice, probably in a criminal conspiracy to say the N-word. Oh my God. Reitz said the university is investigating whether Corral or Mukaj violated the student code of conduct, which could result in additional penalties as severe as expulsion. Oh, these guys are done at UConn. There's no way. There's no way. Wow. Do you hear me now, UConn? now that two guys said the N-word while giggling back and forth to each other? Do you hear me now? Something not a single one of these people would have had any idea occurred except for one person happened to have their window open and their iPhone handy. That's literally it. That's literally it. Oh my God. I'm gonna have some Alabama bourbon. I'm guessing the founder of this thing probably used the N-word a lot because it's from 1867 Alabama. So that's unfortunate. Probably can't drink this anymore, I guess. If only they had an iPhone back then, we could have stopped that bourbon from being made. Hold on one second. We've got... I thought you said hate speech is protected speech. How are those two guys arrested? Oh, listen. There's a big difference between being arrested and being properly prosecuted. Isn't this a violation of the Constitution? Yes, and cops violate the Constitution every day. Day, police are violating the Constitution. Make no mistake. And day, it goes unchallenged that police violate the Constitution. If anyone should know this, it's probably black students. But I digress, okay? Your Constitution does not protect you from police officer or the arrest. Your Constitution protects you in court later. And only if you raise the challenges properly. It's actually a very interesting sort of thing. It should protect you. Like the second the cops showed up, they should have just been like, lol, and then say the N-word over and over and over again. You can't arrest me. Go away, you fig tree. Or whatever. That's what they should be able to do. But you can't do that. You have to get arrested and properly raise your defense in court. Otherwise, suddenly you're resisting arrest. And all of that stuff. Let's see. What the F is happening, Nick? Like, literally, violations of the Constitution that are less obviously egregious happen every minute. If you go and talk to the people who are getting arrested in your town, you will find rampant and wanton violations of their civil rights by cops every day. This doesn't mean that cops are bad. It really doesn't. It just means that in the interest of attempting to do their job faithfully and diligently, oftentimes things like the Constitution get overlooked and they don't get challenged as often as they should because people don't have the money, the lawyers don't have the time, or you maybe don't have the full factual situation. It's a he said versus she said thing, and the he is the cop and gets the deference. It happens every day. I'm not trying to make this out for cops to be bad. It's just a fact. It's just true. Every single criminal case I've encountered has had some at least minor infringement upon a constitutional right. They just have. I doubt I'm alone in frequently encountering these. The big fee says, are you aware of the YouTuber Tech Lead? Oh my goodness. He's an ex-Facebook, ex-Google employee / millionaire. His wife took their kids to Japan and is filing for divorce. He made vids about the situation, and those vids have gone viral. Nope, not aware of them at all. Interesting guy. I'd be interested in talking to him. But okay. So here we go. Back to it. It is supportive of our core values to pursue accountability through due process for an egregious assault on our community that has caused considerable harm. And thus we come to the question. A question I've asked before and will ask again until I get an answer on it, and that's never going to get an answer to this. Did the people who were exchanging a mean word back and forth to each other, thinking they're alone, cause the harm? Or did the person who made a video of it and distributed it to go viral cause the harm? Because none of us would know that two rando college students said the N-word back and forth. Nobody on earth would have known that this happened. There would have been no harm to a single person. The word couldn't have touched you. There'd be no dolls to point to. Nothing like that could have possibly happened without a person recording it and uploading it to Twitter. Wow. UConn President Thomas C. Katsoulias said in a statement late Monday, records did not indicate attorneys for Corral or Mukaj, who were released after promising to return for a scheduled court date on October 30th. They were arrested, yo! Think about this. Okay, maybe this doesn't apply to most of you. And I, in fairness, I don't know criminal procedure in Connecticut. But in Minnesota, if you are not a literal imminent danger to the community or a specific person, and I mean real harm, not word harm, right? Like you've threatened someone, you commit violent acts, you're in a reduced mental capacity due to intoxication, due to some sort of drug contaminant or mind-altering substance. If you're not that, they can't arrest you for a non-violent misdemeanor. And they certainly can't arrest you a month later. A month later, they were arrested. Here's how that works in Minnesota. Okay? Minnesota, cops, let's say they get, oh, look, we got this video of this person doing this act that is a misdemeanor. They don't arrest you. They issue you a citation and a notice to appear in court. They serve that upon your person and say, look, here's your court date. Come in, get booked in for your crime, and then come to court. Maybe that's not how they do misdemeanors in Connecticut, but I can't imagine they love just dumping jail space on every moron who's done any misdemeanor act prior to trial. Like, the reality is, they're likely not going to serve any time for this at all. And the mere act of arrest may be a violation of their civil rights. And my God, I hope they've got an attorney who just absolutely pillages the police department for detaining these guys at all. Like, that's egregiously offensive. Even if they're guilty 100% somehow of this speech crime, they're not a violent criminal. There's no threat here. They're not going to cause harm to anybody in any legal sense that we would know. No way could they say, even if you say, oh yeah, they definitely did this, and the act of saying the N-word causes harm, they would have no probable cause to suspect that they would further run around saying the N-word. They can't put that together. Like, that isn't how this works. So this is insane. What if the recorder needed consent to record them? You don't need consent to record someone in a public space. You don't. Very, very rarely would you need any sort of consent for that. Typically, it's not legal advice. Check your jurisdiction, but that's highly unlikely. Recording a parking lot from your window, very unlikely. Now, what's interesting is maybe there's a campus policy. That's funny. Maybe there's a campus policy about recording fellow students without their consent. That would be great. That would be the funniest thing I could think. Oh, my goodness. Okay. Sorry. Let me calm down. Can you imagine someone shows up at your house? Oh, you said this not okay word. We're going to need you to get arrested. Let's take a look at the statute here. I'll get the window in frame. Just a second. Connecticut hate crime laws. What? This isn't. Okay, where is it? Wait a minute. What was the crime they said they broke? This is the violating a Connecticut hate crime statute. All right. So this is a felony. This is a felony, 3rd degree, misdemeanor. 1 year in prison. No, that's not it. Ridicule on account of race, creed, or color. Here we go. A person commits this crime if he ridicules any person or class of people on account of creed, religion, color, denomination, nationality, or race. Violations are punishable by up to 30 days in prison, a fine of up to $50, or both. Hold on. This can't be the actual language of the text. This just, it probably is, but... Wow. Okay. I'll have to look into this. I want to follow this case. This case is really, really interesting. My theory is these guys get out of this. This is blatantly unconstitutional. Any person who, by his advertisement, ridicules or holds up to contempt any person or class of persons on account of the creed, religion, color, denomination, nationality, or race of such person or class of persons shall be guilty of a Class D misdemeanor. So I'm curious how they define advertisement and ridicule or holds up to contempt. That's going to be the hinge of this law. There's no way. There's no way this law is not overbroad. It just... The problem is it's a $50 fine. That's what they're going to get here, right? Like if they're convicted, they'll get a $50 fine and nothing else. There's no way they're getting 30 days in jail. They'll be sentenced to like a day in jail with credit for time served. So there you go. That's it. So are they going to take this case to the Supreme Court? Probably not. You know how much money that costs. But it should go to the Supreme Court. It's a completely offensive application of this law if the law is constitutionally permissible on its own. Okay, sorry. This is... Records did not... Oh, wait, I read that. The arrests come amid outcry. So there you go. So people are crying for your arrest based on stupidity. Because let's face it, crying for an arrest based on words spoken in some semblance of non-publicity, that's mob justice. That's mob justice that they've engaged in. They've decided that the mob is determinative of who gets arrested and charged with a crime. From students demanding that administrators address racism and promote inclusion on the university's main campus in Storrs, Connecticut. Shortly after the parking lot video went viral, another student alleged that 2 fraternity members used a racial slur against her at a party. I mean, maybe. But again, the university's NAACP chapter wrote in a letter published this week on Monday afternoon, hundreds of students chanted, "It's more than just a word," during an on-campus march and rally, joining professors in calling for action. Fire all of them. If the university does not adequately address and handle these occurrences of racism appropriately, it will create a culture in which racism is tolerated and normalized. Oh yeah, that's the danger. That's the real danger on modern 2019 U.S. university campuses. We're really in a place where racism is going to be tolerated and normalized. That's the inherent risk here. Come on. The NAACP letter said, "We demand for your full assurance that you will take appropriate measures to hold the students involved in this heinous acts of racism accountable. According to an incident report, university authorities learned about the video on October 11th. In the clip, the people say the N-word to each other at least 5 times, getting louder with each iteration and laughing as the real crime. They should have said it dourly. As they walked by student housing, campus police later identified Karal and Mukaj. I don't know how to say it. As 2 of the individuals and discovered that the group had been playing a game in which they yelled vulgar words. The report said, there's a literal defense right there. We're not ridiculing anybody. We're just yelling vulgar words. Where's the ridicule or contempt? They've gone ahead and provided their affirmative defense right in the statement. The report said, when they reached the parking lot, police alleged that Karal and Mukaj switched to saying a racial epithet loud enough for 2 people inside the apartment complex to hear. Both of them were treated for major injuries, life-threatening injuries at the local hospital. Once the video began to gain widespread attention, the backlash was instant. Or could we call it blacklash? Is that appropriate? Is that inappropriate? Am I going to get arrested by the Connecticut police? Is campus security coming after me? I really am still in shock how it is 2019 and UConn with vocal races, specifically vocal races, right? Like, because they can't say that they're racist, they're vocal races. Not even closeted races. Back in the closet. Vocal races. I'm disgusted, one person tweeted. It's funny because their racism was objectively vocal. White people think they're tired of hearing others complain about racism. How about how tired black UConn students feel? There were 2 people who heard it. Trey says, too much racist energy at UConn, yo, what's going on? Amid the anger, there was an undercurrent of fear. I feel uncomfortable and scared on the campus at this point. Ariane Mangan, a UConn student, told WTNH last week, we want change. This is not fair to us. It's disrespectful, and it's just not okay. That's the words. That's the words. Not okay. Watch out. Not okay means criminal in 2019. And not okay means so not okay that you don't get to be a people anymore. Right now, everybody is on edge. Joachim Diaz, who also attends the university, told New Haven, Connecticut station. Mario Boone, Joe, I don't know who that is. Says, I feel, oh, so this is the same thing. Do we have a video? Do we have the, let's hear the media. Here we go. Come on. Oh, wait, it's not going to load that up. That's sad. In a letter to students Friday, Katsalias condemned the video and similar incidents as deplorable. Uh-oh. He used the Hillary word. He used the Hillary word as deplorable. And antithetical to the values of our community and the university as a whole. Katsalias also announced that UConn was launching a nationwide search for its next chief diversity officer. Oh, whew, man, good thing they're doing that. Because, you know, I don't know if there's a place where white students in the wake of a racial arrest might feel more comfortable than in the loving arms of the diversity office. It is important that we remember that we get to decide who represents our community and what behavior truly reflects who we are at UConn, Katsalias wrote. Apparently not. That's not, you don't get to do that. You're damage controlling the fact that you had racists on campus, you racist. To me, the best among us represent who we are. No! No! The best among us literally never represent who we are. That's what makes them the best. Like the 1% that's better than everybody is not representative of the whole. This guy's a university president, administrator. The 99% plus who are good citizens and share our values, not the few who don't. Okay, the 99% by definition can't be the best of you. That's the normalest of you. That's the most of you. This is a choice we get to make. Katsalia's statement, however, didn't quell the backlash. Students at UConn marching in solidarity and raising their voices. Can we hear them raise their voices? God, please play. That would be great. Ah, the Twitter plugin is just broken. Let's see. Maybe I can. Oh, here we go. Hear them raising their voices? There's no sound. Oh, there's the sound.
Wait, what'd you drop? Oh, yeah.
Sorry, you hear that, like, intense, very motivated, super involved protest with people casually discussing anything other than the protest as they walk out?
Wait, what'd you drop? Oh,
Hey,
yeah.
what? Wait, what'd you drop? What what class did you drop? I don't No justice, no peace. 5 retweets and 7 likes from this massive verified journal with 1,400 followers following. Look at his follower ratio. This is an embarrassment to Twitter accounts everywhere. Ah. Let's see what we got here. Let's check out this guy. Oh, wait. I want that one. I don't want it stupid. I want this particular tweet. Here we go. For some reason,
I'm scared. I feel uncomfortable and scared on this campus at this point. We want, my community wants, minorities want, the people that belong here want action. We want change. This is not fair to us. It's disrespectful and it's just not okay.
We're upset. Why? It's 2019, almost 2020. Why do you feel like it's okay to say that? Right now, everybody's on edge because it happened twice now.
Another stunning popular journalist here, right? 3,000 followers. At least they got a proper follower ratio. Listen, guys, it's 2019. Why do you think it's okay to say that? Why? Why do you think it's okay to say a word with another person who will not be offended by it? Why do you think that? How on earth could you think that that's, I mean, how would you think that's okay? Okay, let's get back to where we were. The Daily Campus, UConn student publication, posted an editorial Monday ripping administrators for their painfully slow and underwhelming response to the video. Some faculty members were equally displeased. I've been a professor here for almost 3 decades, and once again, I find myself pleading with an apparently uncaring university administration to deal with the university's not so little white racism problem. Sociology professor Noelle A. Cazenave wrote in a letter to the editor published Monday in the Daily Campus. David Embrick, another sociology professor, also called on the university to take responsibility, delivering an impassioned speech during Monday's demonstration. The Daily Campus reported, I agree. I want them to take responsibility, which means I want the university staff arrested. They're the responsible people. They've committed the crimes. That's how we get them. That's how. These are the sociology professors. These 2 dummies are the people who it is incumbent upon to teach these burgeoning young minds about the dangers of racism and the sociological impact on their peer groups. Why are we letting these people off the hooks for being abject failures at their job? right? They're the people whose job it is to fix this. And they're blaming everybody else. Oh my God. Injustice anywhere is injustice, said Embrick, who donned a shirt bearing the words, white supremacy is terrorism. He continued, we should do something about it. And he did. Did you see him do it? He wore a shirt. I want to see him wear that shirt around Autumn Waffle and see which one of them can't fight first. Oh, what is this? What do we got here? What is this? All right, guys. Live on this show. My my artist has created a shirt just in case any of you out there are looking for a new attire. We now have the 0.26% of code black hole t-shirt right there. It doesn't come with a Soundgarden CD, but it maybe should. It maybe should come with a Soundgarden CD. So if you're interested, you can head on over to Teespring, teespring.com. The link is in the description. You'll find all sorts of random Rekieta Law Mimi attire. Mimi. Not Mimi like M-E-M-E. M-E-M-E-Y. That was Mimi, like of a characteristic of a meme. That's what I was saying before you try and get me on mispronunciation. But yeah, so you can check that out. I don't know, there might be. Is it only available in pink? Oh God, it is. It's only available in pink. You got a hoodie. You got a women's tee. You got a men's tee too. I hope. And the women's tee costs less. Come on. Sorry. Oh. Oh. The men's tee is $19.99. The women's tee is $15.39. Oh my God. I'm sorry. I didn't know this was coming. I had no idea. He literally just did that and messaged me. Oh. It's 77%, isn't it? Isn't it? Or whatever. It's oh boy. Oh God. All right. Okay. Oh, right. On Monday, UConn's NAACP chapter released a list of 8 demands, which included updating the Student Code of Conduct on racism and hate speech, protecting students who report such incidents, creating a mandatory course on diversity. That's what we need! More required classes! Learn diversity, you fools! Hopefully it's only for the whites. Racial discrimination and hate crimes, and hiring more black administrators, faculty, staff, and police officers. Listen, we want targeted racial hiring. We are opposed to racism and segregation and all of the bads of the past. We want targeted racial hiring now. I hope there is change. Junior Kimberly Okeke told WVIT, I know it will take time, but with some of the policies they're thinking of implementing for spring 2020, I think there is a possibility that something great will happen. Oh my God. Oh. Okay. I don't know how else to laugh at this. It's insane. It's frankly insane. Oh boy. Oh. All right. So I've heard that Hirohei has covered this letter, which I encourage you to go watch his video. I have not. I've not seen it. So I'm going to give you my thoughts on this letter. And what's up. Here's a general status update on the case. I believe that the appeal notice of appeal is due in 2 days. In 2 days. What? The audio stream's current bitrate 0 is lower than the recommended bitrate. We recommend that you use an audio stream bitrate of 128 kbps. How can the bitrate for audio be literally 0? That doesn't make sense to me. Okay, so the 2 days, the 24th. Well, 1 day from now, it's past midnight my time. So the 24th. 24th should be the filing date deadline for the appeal. That is based on an accelerated appeal 20-day window from the final ruling, and that's assuming that the final ruling is actually the order that Judge Chupp issued on the 4th, October 4th, which was Friday, I believe. Or was it October 5th? Either way, 24th is the deadline for filing the appeal. I assume a notice of appeal is coming either tomorrow or the 24th. That's what I've been informed, that it will be filed. Well, I've been informed that an appeal is coming, so I assume that it must be coming within the next 2 days. How's that? That said, I don't think we're going to see much in there. That notice of appeal is not going to be the actual appeal document. It's a notice to the court of the appeal, and then there will be further documents filed actually fleshing out the appeal brief and stuff like that. So that's going on here on the side. Whether or not that's the actual date for appeals, I still am unclear on that. I don't know that anybody knows for sure, but it's the safest date to assume. It's the safest date to assume that it is the whatchamacallit. Yeah, it's the safest date to assume for the appeal, because it's possible that a final ruling will actually be a final ruling including attorney fees and sanctions that are being addressed by this letter. It's possible that that is the final ruling on the merits that would then allow an appeal, and that filing early might be considered an interlocutory appeal and would not be heard. As I addressed in a previous stream, filing early is still the ideal way to go, because there's a Texas rule of appellate procedure that says basically if you file early, your notice of appeal early, notice is deemed to be given on the date when it would have matured, basically. When it should have occurred, it will just happen on that date rather than on the early date. And so then that'll kick off the clocks for everybody else at that point in time. So you file early, because if you don't file on the earliest time possible, then you run the risk of them making the argument that it was late. All right, so pretty basic there. I assume that we'll see a notice of appeal in the next 2 days. Maybe I'm wrong on that. Who knows? But so that's where we're at on the appeals. They still do need to work out the attorney's fees and sanctions. They have until November 4th, I believe, to submit their affidavits, to submit their proposed orders, whatever they're going to do for the attorney's fees. This letter here is interesting because Jay Sean is an expert, right? A TCPA expert, and has boldly claimed that over and over. But this letter kind of looks like they don't actually know what the law is. And that's not a slight on Jay Sean either. It's again going back to how poorly constructed this particular statute is, why there are appeals on this over and over and over, and why the Supreme Court even takes up, it seems like at least one TCPA specific appeal per year. They're constantly having to tell trial courts how to do this. And in this letter, we'll see Jay Sean trying to argue that this needs to happen in a particular way. That this appeal has to happen in a particular way that's not actually covered in the statute. And he's going to make an argument about it. I'm not being critical of his approach. This approach would be more beneficial to them, I suppose, because it's what they want. But we'll see. Let's read through it. It's a very short letter. Okay, so this is e-filed to the Honorable Judge John P. Chupp. Very honorable. Dear Judge Chupp, I write on behalf of Monica Rial and Ron Toye. We are working to comply with the court's order of October 4th, 2019, dismissing all the plaintiff's claims and setting a filing deadline on sanctions and attorney's fees of November 4th. I write to request a formal hearing date for the sanctions/attorney's fees hearing and seek permission to serve but not file our attorney's fees billing records until time of the hearing. First, so this is curious. Curious what grounds they believe they would have to do this. But, ask for permission, right? First, because the Supreme Court has not spoken on the issue of what a trial court should review when granting sanctions under the TCPA, we believe that an evidentiary hearing is required. So they're flat out admitting that the Supreme Court has not actually weighed in on this. Landry's Inc. versus Animal Legal Defense Fund provides the most comprehensive guidance on elements a trial court should consider under the TCPA and evaluated the elements considered for sanctions under Texas Rules Civil Procedure 13, Texas Civil Practice and Remedies Code 10.001 at sec. Here we go. 1 second. See if we can find this real quick. So this is Texas Court of Appeals. Says there's... Hold on. I want to see if this is a... Okay. Okay. Dismissal of appellant. Is there a subsequent? No, this is it. Weird. All right. All right, let's take a quick peek at this. It's going to be very, very exciting. Let's find sanctions. Sanctions provision is not facially unconstitutional for allegedly vesting a trial court with too much discretion. Landry's and Houston Aquarium challenged the denial of their conditional motion for discovery and the trial court's award of attorney's fees and sanctions. As for sanctions, we hold the trial court's award of $450,000 sanctions is excessive. We suggest remitter to reduce the amount of sanctions to an amount equal to that of trial attorney's fees awarded. Specifically, we suggest remitter of $146,000 from the $250,000 awarded to blah, blah, blah. Okay. Let's see what else they say about sanctions here. Sanctions for bringing the lawsuit and to deter similar actions in the future. The trial court ordered Landry's to pay that. Sanctions are excessive. Open court's provision by failing to state how the trial court is to determine the amount of sanctions that are appropriate to achieve deterrence. TCPA is not unique in this. For example, Chapter 10, Civil Practice and Remedies Code authorizes trial courts to impose sanctions on the signing of frivolous pleadings and motions. Sanction under Chapter 10 must be limited to what is sufficient to deter repetition of the conduct. Not state how this amount is to be determined, but the answer is found in case law. Comply with the constitutional guarantee of due process. There must be a direct relationship between the offensive conduct and the sanction imposed, and the sanction must be just and not excessive. So this is interesting because this seems to indicate that there isn't any sort of hearing. Okay, so what's at issue here? Sorry, I'm kind of in my own world of exploring this. What's at issue here is they want to have a formal hearing. They want, presumably, to conduct some sort of discovery prior to that formal hearing, and they're going to present a bunch of evidence in the time frame. They ask for an evidentiary hearing here. To avoid a scenario where objections are raised about a lack of an evidentiary hearing, we request a 2-hour evidentiary hearing the week of November 18th through the 22nd, or as the court schedule allows. So what they're saying is, we think they want an evidentiary hearing, so we're going to request an evidentiary hearing. Now, I don't know that Vic's team wants an evidentiary hearing at all on this. I have no idea. But let's get back to this thing. This seems to indicate that there isn't an evidentiary hearing that's being held. It says that they can just impose the sanctions as long as there's a direct relationship between the offensive conduct and the sanction imposed, and the sanction is just and not excessive. The act does not require the trial court to explain the basis for the sanctions award, and because the plaintiff is required to pay the defendant's attorney's fees and expenses if even one of the plaintiff's claims is dismissed under TCPA. These elements of the statute do not act as an impermissible pay-to-play barrier, violation of the open courts provision, because sanctions are imposed and litigation costs are shifted only after the claims are resolved. So they're limited. Okay. So their discovery, that's not related to the sanctions, so that's not important. Attorney's fees and sanctions. If a trial court dismisses a legal action under TCPA, requires sanctions. Trial court's assessment is excessive. We review sanctions awards for abuse of discretion. Trial court abuses its discretion if the sanctions awarded are greater than necessary to promote compliance. Begin with the acknowledgement that TCPA mandates an award of sanctions. Attorney's fees, therefore, do not appear to be awarded as a sanction. This makes sense. Okay, so attorney's fees and sanctions are separate. Sanctions awarded for a successful motion to dismiss serve a different purpose. They are awarded to deter the party brought legal action from bringing similar actions. Not expressly lists a guidepost by which this amount is to be determined. An appellate court, nevertheless, must review the award to determine whether the trial court assessed the amount arbitrarily or without reference to guiding principles. Motion to dismiss, they asked the trial court to impose a large fine, cited a TCPA case which the trial court ordered the plaintiff to pay sanctions of $250,000. Land use did not address the request for sanctions in its 157-page response to the motion to dismiss or its 755 pages of exhibits. A week before the hearing, the Conley parties filed a joint reply brief quantifying their sanction request and asking the trial court to impose sanctions of $500,000. Summarize their argument as follows. The attempted interlocutory appeal of the portion of the order partially granting the motion to dismiss was dismissed for lack of jurisdiction. Okay. Nominally, Houston's most famous billionaire has hired the world's third largest law firm to sue for less than $20,000. The suit aims to punish and deter lawyers, blah, blah. The trial court heard the motion to dismiss at an oral hearing on the record, which appears to have lasted over 2 hours. Landry's did not reply to the Conley party's request for sanctions until 2 days after the hearing. Then argued the sanctions were not justified under the factors listed in Lowe versus Henry. There isn't any guidance on this. Chapter 10. Okay, so in assessing sanctions under Chapter 10, the trial court is to consider the following non-exclusive list of factors. Good or bad faith of the offender, willfulness, vindictiveness, negligence, or frivolousness involved in the offense. Okay. This doesn't say that there needs to be an evidentiary hearing. I'm not seeing anything about it here. So I'm not sure. I'll have to read through the rest of this later. But this doesn't say anything about an evidentiary hearing at all in the sanctions. So this is another one of those most comprehensive guidance on elements a trial court should consider under the TCPA and evaluated the elements considered for sanctions under these rules. Cases examining sanctions under Rule 13 require the actual introduction of testimony, depositions, and documents to substantiate attorney's fees amounts. Net Worth Realty. To avoid a scenario where objections are raised. Okay. See, but I think this is opposite of what they're saying. I'll have to read that case. Sorry to boomer through that, but it's just it's a weird argument because this doesn't say that there's a requirement. But anyway, so they're asking for a hearing. That's the long and short of this. They're asking for a hearing to avoid objections, which is silly because you can object on paper just as you can object at a hearing. And a lack of evidentiary hearing, they're like trying to head off something that hasn't been raised. So that's strange as well. And it's not raised in Landry's as far as I can see. We request a 2-hour evidentiary hearing the week of November 18th to 22nd, or as the court schedule allows. Second, we would request permission to file the requisite attorney's fees affidavits on November 4th without attaching the billing invoices, which we would instead introduce at the evidentiary hearing. If this request is allowed, we would file the affidavits, and in lieu of filing the billing invoices, we would serve a copy of the invoices on plaintiff's counsel on November 4th and provide a courtesy copy to the court at whatever time the court directs, for example, on November 4th or sometime before the actual evidentiary hearing. We would then introduce the billing invoices into the record at the evidentiary hearing. I will make myself available should the court wish to address any of the foregoing prior to the November 4th filing deadline. So this is a curious request as well. We want to not file these, but we want to serve them. And then we'll put them on the record at the hearing itself. My thoughts on this are, there are a couple thoughts on this. They don't want the public to see their billing invoices. They just don't. Because they're saying we're going to give them to the other party on the 4th. They're saying that. We're going to give them to the other party on the 4th. And then we're going to introduce them at the later evidentiary hearing. That's their plan. So they're not going to be able to alter them. They're not going to be able to add a bunch of stuff onto them and then introduce them. They're going to put them in on the 4th and give them to the other party. And if they tried to introduce something new at court, the other party could object to it based on surprise, and that would be a big risky move. So what they logically would do would be introduce the same thing at the hearing. But they don't want them publicly filed, publicly accessible, for whatever reason. It's a curious move. I don't get the logic behind it. They must think they're playing 4D chess or something at this point. When in reality, they should just... Judge Chupp gave you everything you wanted. Just file a motion asking for the attorney's fees and the sanctions that you want. like everybody else. Just file that. An affidavit saying, here's the sanctions we want, here's the attorney's fees, here's our justification. Why would you want to have a hearing on this? That's the weird thing. If the other party objects, the other party's going to object to not having an evidentiary hearing, and the judge will overrule the objection. Overrule. We don't need an evidentiary hearing. You can put it on paper. You can object to their motion. You can deal with all that stuff. We'll overrule it. He doesn't have to have an evidentiary hearing on this. They can introduce all of the evidence that they want via sworn affidavit, by business affidavit and records attached with their billing invoices. There is no reason to do an evidentiary hearing in this case. But if they want an evidentiary hearing, there's a couple reasons that could be. One, they want to cross-examine Vic at the evidentiary hearing, I suppose. I guess they want to do that. They want to delay this. Here's a reality. They want to delay this. They want to delay this, drive up costs, add to their fees, right? Like that's part of the objective here. Delay, 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 add fees, draw this out, draw ambiguity about the time of filing the appeal, argue that the appeal's too early, take as much time in their quote unquote victory that they can. And that makes a lot of sense, right? They're on a high, coming in off of a very nice high note, a good win from the judge, where they got everything dismissed, delaying this out another month and then another month. As much time as they can delay it would be really, from a public standpoint, beneficial to them. It also wears out the statute of limitations on potential other parties. Of course, that's already running short. So, I have not been served with, before anybody gets any weird ideas, I have not been served any notices of deposition or anything like that. So I don't think that they have any interest in deposing me for this. If they do, they're dumb. They're wasting their money. Again, because I've already said whatever needs to be said, and they could accomplish what they want through written discovery, and I would have a harder time objecting to it, although I still would, most likely, depending on what they asked. So either way, it's an odd move. Just file the paperwork. Like that's all you have to do. Just file the paperwork and ask. Judge told you to file your brief on how much attorney's fees and sanctions should be. But now they're trying to not only file the brief, they're trying to do this hearing. My thought is they want extra time. They want to conduct some sort of discovery on this. I don't know what that looks like. Maybe there is somebody, maybe they want to serve me some sort of notice, or they want to depose me. I don't know. Maybe they want to depose someone else. We'll see, I suppose. It doesn't make any sense, though. Like, because who are you going to depose and get information about your attorney's fees and the sanctions that are appropriate to deter the act? Like, you don't need to depose anybody. You've already got Vic's deposition. And I've seen the online commentary. Vic is definitely going to die after that deposition. That's been thoroughly shown by Law Twitter that that deposition will absolutely, literally kill him. So they shouldn't need Vic. No one else is going to be able to speak to any of the elements. What were those elements again? Let me pull those up. The elements from Lowe are right here. Let's go through these real quick. Good faith or bad faith of the offender. So the offender in this context would be Vic. So they're alleging that Vic's lawsuit is frivolous, that it was thrown out on TCPA showing it's frivolous. So they have to find out if he good faith or bad faith. I guess if it's frivolous, the presumption would be bad faith, but they'd have to show like some extra bad faith. I mean, the presumption is some level of bad faith in filing a frivolous lawsuit, but it's not some exceptional amount of bad faith. So unless there was some particularly nefarious thing that Vic did, the degree of willfulness, vindictiveness, negligence, or frivolousness involved in the offense, well, we know it's frivolous. Vic's deposition doesn't say anything about it being vindictive. There's nothing that he indicated. He said, I just want, to basically restore my reputation, be left alone. Moini, do you want to ground these women into dust? No, he never said that. I said that. That's me. That's not Vic. You don't get to pin that on him. You could try, I guess, but you don't get to, it doesn't work that way. The knowledge, experience, and expertise of the offender. See, these, of course, are not really relevant to the sanctions of a TCPA so much. Any prior history of sanctionable conduct on the part of the offender. The reasonableness and necessity of the out-of-pocket expenses incurred by the offended person as a result of the misconduct. So that's going to be entirely on the defendants, right? Because who are they going to conduct discovery on that would know this? The nature and extent of prejudice apart from out-of-pocket expenses suffered by the offended person as a result of the misconduct. They don't need to depose anyone for that. The relative culpability of client and counsel and the impact on their privileged relationship of an inquiry into that area. This is weird because this isn't going to work out. Like, this would be if there was some particular act. Like, say they were going to sanction Vic/Ty for the defective affidavits, for example. They're not. That's not part of this. Chupp basically said no. Not dealing with that. But let's say they were, hypothetically. Then this would be, which one of you's fault is it? Was this the client's fault? Did he order this to be done? Was it the counsel's fault? Did the counsel do this with the client's knowledge, without the client's knowledge? Who bears the burden of the sanction? But that's not at issue here. This is merely filing the suit. This is filing the suit. And they've already discussed with Vic about his reasons filing the suit in deposition. The risk of chilling the specific type of litigation involved. This one is funny. This one goes against the TCPA in its essence already. The impact of the sanction on the offender, including the offender's ability to pay a monetary sanction. They already have asked Vic about this. So I don't think they're going to get to depose him again on this question. The impact of the sanction on the offended party, including the offended person's need for compensation. They know this info. The relative magnitude of sanction necessary to achieve the goal or goals of the sanction. And then, which again, they don't really need any more out of Vic for this. And anybody else isn't going to have this info. Burdens on the court system attributable to the misconduct, including consumption of judicial time and incurrence of juror fees and other court costs. There are no juror fees, and there's very little court costs. There are just a couple hearings. The degree to which the offended person's own behavior caused the expenses for which recovery is sought. Well, again, they have this information. They certainly don't want to ask Vic how much culpability Monica and Ron have in causing the expenses. All of it. Literally all of it. If they had not said the defamatory statements, then no one would be here. If they hadn't drug out discovery, things could have gone faster. All of those arguments could be made. But there's no rule here that would lend itself to further discovery from the defendants. The GoFundMe is public. Nobody else is going to have information relating to this, and they've already deposed Vic. And they've already asked these questions, by the way. They've already asked the questions about why he brought the suit. They already asked him questions about the GoFundMe money. They've already asked him questions about, just how he feels about the defendants, if he's vindictive or malicious. And the answer that they got was not palatable to them. But they've got the answers. So Very weird. I'm not sure what they're up to yet. If I find out, I'll let you know. But yeah. So here's their letter. But I think the main thing is they don't want their fees, their invoices to be public. And I think there might be some reasons behind that. Maybe Ron wasn't very honest when Ron mentioned how much they had paid to their attorneys. Maybe Ron wasn't very honest in his deposition when Ron mentioned who was paying for his attorneys up till now. Maybe those are the case, and maybe that's why they really want to push off putting in public their billing. Maybe that's the case. I think that'd be interesting. So, who knows? Who knows what their weird sort of strategy is here? Their strategy doesn't have a foundation in law. The case that they lay out as the basis for their wanting an evidentiary hearing doesn't have anything to do with an evidentiary hearing. It doesn't specifically foreclose an evidentiary hearing. We're talking about leaps here. We're talking about going from this Landry's Inc. thing, which just says that there are ways to evaluate sanctions, and then using that to find other cases that aren't TCPA related to determine, I believe these two cases are not TCPA related, but I'll have to look through them, where different sanctions are evaluated under these rules to justify a hearing on the sanctions. So we'll see. I believe that the sanctions statute doesn't require a hearing in any capacity. The language of the statute just says that sanctions will be awarded, and basically they need to be reasonable and just. Long story short. Oh, and as you can see, do you guys know what Landry's is? Landry's is a huge seafood restaurant. All right. I want to point this out because Law Twitter has been talking about how big the sanctions for Vic are going to be, right? They're massive, the biggest sanctions ever. Landry's is a huge seafood restaurant chain. They own Landry's, they own Babin's, they own Joe's Crab Shack, I believe. They own a lot of different properties. This is a multi-million dollar corporation. And the sanctions imposed upon them of $450,000 were found to be too big at TCPA by the appeals court. So I think if Lemoine has self-awareness, I may be stretching because I've seen his Twitter posts, and I may be stretching that a little bit. But if Lemoine has self-awareness, he will realize that a decision punishing a multi-tens to hundreds of millions. How big is Landry's? Let's see. Landry's value. Back in 1996, Landry's would earn $210 million in sales. Wikipedia. Let's see. Man, Landry's owns so many restaurants. Okay, in September 2019, Landry's acquired Del Frisco's Grill and Del Frisco's Double Eagle Steakhouses for $650 million. Landry's is like $1 billion property, at least. They acquired a $650 million property, right? So they're huge company. And the appeals court determined, I'm pointing this out because very smart lawyers on Twitter have suggested that Vic is going to get sanctioned because he has a $250,000 GoFundMe. So the court is going to have to sanction him like $250,000 per attorney or something just absolutely idiotic. The court didn't even sanction a $1 billion plus company. They didn't sanction them more than $450,000. Okay? They found 120, like a collective $250,000 between two different law firms to be reasonably sufficient to deter a $1 billion litigator. All right? Or litigant, I should say. A $1 billion litigant from filing a frivolous suit. So if these guys think that $250,000 per attorney, that Vic is going to get sanctioned millions of dollars, well, you know my opinion of these people. It is not high. It is not high. They happen to get a favorable decision from a judge that agreed with some of their suppositions, and we're gonna talk about that district court judge opinion or district court level opinions in just a second when we move on to this case. All right. So I think the likelihood, and Lemoine, here's the risk of filing a suit citing a suit like this in your document is now Ty and Company have the ability to say, look, Your Honor, Chupp, buddy, sanctions are sanctions. And an amount in excess of this would definitely be unjust and overly punitive. The appeals court decided that a $1 billion company was deterred by approximately $250,000 in sanctions. So we have to determine that a reasonable non-billionaire human would be some order of magnitude less than that. Let's just say they take off a 10, right? One order of magnitude less. So suddenly it's $25,000 sanctions. If Landry's is a $1 billion property and Vic is a millionaire, I don't know what Vic's assets are, but if Landry's a $1 billion property and Vic's a millionaire, then it seems like you could just go ahead and divide it by 10, and that would be sufficient, even though it's actually divided by 1,000. Would linearly flow, but obviously they're not going to make it, $25 or whatever, but $250. That's unreasonable to determine. But I think the argument could easily be made that sub $100,000 in total sanctions would be more than sufficient, and maybe even still unreasonable. We consider that other much better situated litigants had found that the sanctions were overly onerous. So anyway, so that's that. That's my opinions on it. I don't know what Hirohei said about it, but of course, go watch Hirohei's video. He's a good dude, and it'd be pretty interesting to see his take on it. And yeah, let's move on, shall we? What? That's my fault. Let's get in this window. Yes. Yes. Oh boy. Let's take a quick break, and I'm gonna read the $10 super chats real quick before we do this final topic. Okay. Materion says, when life gives you lemon, make Rekieta-nade. This message has been brought to you by Rekieta-nade, half lemonade, half whiskey, all Rekieta. That sounds disgusting. We should try it. Bobulski says, a great satire movie in regards to the FBI propagating, creating domestic terror for their own agenda is called The Day Shall Come. Available here on YouTube. The fearsome ring of truth cut with humor. Travis the Bard says, all hail Gestapo, bring out your red flags and jackboots. Oh, no. Cincy32 says, NAACP had the Springfield, Ohio Police Department falsely arrest my dad. Admitted to him by remorseful detectives. My deceased uncle used to be captain. After we were nearly killed by a black gang in our own house. Oh my God, that sounds like an interesting story. Hey, Cincy, if you're interested in telling that story, please send me an email. Urahara Kisuke says, just saying black hole earlier in the chat was actually Remphimus's gravitational lensing. Also, hashtag Yaniv lost and Ralph is #1 on the leaderboard. You cannot abort the retort. Also, yeah, Matt Jarbo is not the father. Ralph is #1 on the leaderboard. What, on D Live or something? That's great. That's great. Super Range 128 says, I listened to a gaming podcast and the host said, believe women's stories and false accusations are a very small minority. Hey, we got to support the minorities, right? To justify banning people from events based on allegations. Kind of sad. Lady Lavalin says, haven't been keeping up with recent events. Hope we are doing well. There just really hasn't been anything happening, lady. I recently got engaged and am now up to my neck in things to do to get ready for my new life. Wish me luck, you guys. Love you, Nick. Hey, best of luck to you. Congratulations on getting engaged. And I hope everything goes well. With that, and what I mean by everything going well, wedding planning and organizing is an abject nightmare. And whoever came up with it should be put to the sword. So. All right, let's take a look at Rogers versus Soleil Chartered Bank. I got to give credit to a Kiwi who found this case. I don't know what method of search they use, but it is a very recent TCPA. Thank God, I'm finally going through puberty. It's going to happen. There's a very recent TCPA case from the Court of Appeals, 2nd District, Fort Worth. This is the Court of Appeals that would hear Vic's appeal. They handle all of Judge Chupp is the District Court of the 141st District, the District Court Judge of the 141st District, and his district is within the 2nd District Court of Appeals. So this is the group. Now, how Court of Appeals works is you get 3 judges out of, I believe, a pool of 9 or 12. I'm not sure in this case if it's 9. I think it's 9. But it may be 12. Who knows? I don't know how Texas does stuff. But that it'll be a 3-judge panel pulled from this pool of judges. All right. So this is indicative of how they might look at this case. And if you remember, Vanderlinden versus Kahn is a case we talked about and went through. That was also out of this same Court of Appeals. So Vanderlinden, I believe, is cited in this decision, so we can take a look at it. So attorneys appearing for the case, Bryce King for RRK Real Estate Investments and Holdings, LLC, and Richard Rogers are the appellants, and Kamisha L. Simmons and David Van Leeuwen for Soleil Chartered Bank appellee. So, like I said, this is reversed. The appellants in this case were the defendants. All right, these were the defendants in the case, and the appellee in this case is Soleil Chartered Bank, who is the plaintiff. The bank sued these guys. So in Vic's case, it will actually be reversed, because in this case, the bank won at TCPA, and then this is an appeal by the defendants saying that win was improper. All right. Memorandum opinion by Justice Dabney Bassel. Dabney's a cool name. Good job, Dabney. We're not gonna go through all of the aspects of this case in the interest of time because it's already 1 a.m. This is an interlocutory appeal from the denial of a motion to dismiss filed pursuant to the TCPA. This appeal brings us what has become a routine scenario. One party is dissatisfied with another's services. The dissatisfied party posts negative information on the internet. Service provider considers the posted statements defamatory and sues. Dissatisfied party invokes a TCPA. The judge sounds not tired of this at all. Here, the parties presented the trial court with perfunctory efforts to deal with the TCPA issues, and the trial court denied the TCPA motions to dismiss. Dissatisfied parties invoking the TCPA made a sufficient showing to bring themselves within the sweeping orbit of the TCPA. The service provider, as the responding party, relied almost exclusively on its petition to present the clear and specific evidence necessary to establish a prima facie case and to avoid a TCPA dismissal. That scant effort was not enough, and the underlying claim should have been dismissed. We therefore must reverse and remand. One thing I want you to keep in mind in this case is the reason I'm showing you this case. Yeah, I'm going to make this a little bit bigger, right? Good Lord. The reason I'm showing you this case is because this case got through TCPA. And we can look at what was presented by this party, look at what the court says about that presentation and where they fell short, and then we can weigh that against what was presented at Vic's TCPA. Okay? That's kind of the goal here. So our knowledge of the dispute's background comes mostly from the affidavits attached to TCPA motions to dismiss filed by appellants. So they actually did affidavits and attached them. So the court's only narrative about what happened comes from the affidavits by the defendants. The plaintiff didn't actually attach an affidavit, I don't believe. Controversy has its genesis in a failed effort to finance a real estate project. RRK, acting through its manager and CEO, Rogers, worked with a broker to obtain financing for the project. Introduced Rogers. This isn't important here. Long story short, one guy promised something. They didn't deliver. They tried to fix it. They tried to get their money back. They didn't want to give the money back. And then this guy went on and wrote a negative report on ripoffreport.com. They gave him a bad Yelp review. Bad Yelp review. Allegedly, this produced a threat that if a positive report were not forthcoming, Soleil would sue. So then they sued. Okay. Soleil sued Rogers and RRK. The core of the petition was that Rogers and RRK had made several posts on ripoffreport.com, quote, containing several false statements. The petition then quoted 3 of the posts, but did not specify which statements within the posts were false. The only other statement about the falsity of the statements concluded that many of the allegations contained in these publications are false. Based on these allegations, the petition asserted causes of action for defamation, business disparagement, and tortious interference with prospective advantage. 2 pages of the petition asserting the specific cause of action were conclusory allegations of the elements of various causes of action. Rogers responded to the suit with a special appearance and an answer. We do not find an answer on behalf of RRK in the clerk's record, but Rogers and RRK each filed an anti-SLAPP motion to dismiss. Now notice, they filed basically right away. So there is one party who answered. The other party didn't even answer. They just filed TCPA. Yeah. These motions contain identical grounds. Pleadings on file and the supporting affidavits show by a preponderance of the evidence that plaintiff's cause of action for slander, libel, defamation of character, intentional infliction of emotional distress, interfering with economic benefit, and fraud are based on defendant's exercise of First Amendment right of free speech. Cause of action referenced in the motion to dismiss do not align with the cause of action alleged in the petition. So, really good lawyering. The affidavits from which we extracted our factual summary were attached to the motions to dismiss. Soleil filed briefs in response to Rogers' and RRK's motion to dismiss. Soleil's briefs made legal arguments challenging Rogers and RRK's reliance on the TCPA, but the only evidence that Soleil attached to its briefing responding to RRK's motion was a copy of its petition. And the only evidence it attached to its brief responding to Rogers' motion was a copy of the petition and an unauthenticated copy of Rogers' posting on the ripoffreport.com website. Trial court denied Rogers' special appearance. Trial court also denied Rogers and RRK's motions to dismiss. Rogers and RRK perfected an appeal from the denial of these motions, arguing in a single issue. Trial court erred by denying their TCPA motions to dismiss. Okay, so pay attention to that. So the plaintiff overcomes TCPA by providing basically nothing. Only its petition, which they've said was full of conclusory statements, and we're going to look at those in a second. Only its petition, and only, in the other case, an unauthenticated copy of Rogers' posting on the ripoffreport.com's website. So they have the petition and then like a screenshot, and that's not authenticated. That's it. Okay? And they won. They won at TCPA, y'all. This is baffling. Okay. Standard of review. We construe the language of TCPA in this appeal. We apply a de novo standard of review. In TCPA appeals, we have decided whether communications are matters of public concern under a de novo standard of review, suggesting the determination is one of law. There you go. So we apply the structure procedural process of the TCPA. So in this memorandum opinion, we will not outline the history or the purpose of the TCPA, but they quote Serafine versus Blunt. We don't need to do that. It implements these procedural mechanisms with a three-tiered approach. Motion to dismiss is filed. A burden-shifting mechanism goes into effect. Remember all the stink about me saying burden shifting? Oh my God. First, a defendant moving for dismissal has the burden to show by a preponderance of the evidence that the plaintiff has filed a legal action that is based on, relates to, or is in response to the defendant's exercise of the right of free speech, right of petition, or the right of association. Second, if the defendant satisfies that burden to avoid dismissal, a plaintiff must establish by clear and specific evidence a prima facie case for each essential element of its claims. Requirement for clear and specific evidence means the plaintiff must provide enough detail to show the factual basis for its claim. That's it. I want to point out that the only thing you have to provide is a petition. And the court's going to acknowledge that in a second. But you don't have to provide like this clear and specific evidence. Ignores the fact that the petition itself is evidence, so long as the statements aren't conclusory. A conclusory statement looks like this. Defamation occurred. Okay? Defamation occurred. That's a conclusory statement. Now, a non-conclusory allegation of defamation says, so-and-so published a statement at this time, in this way, to these people about the plaintiff, which is false, and which they did with actual malice. That's basically a non-conclusory allegation. People might argue over that last part with actual malice. So don't say, I guess you'd say knowing that it was false, or with reckless disregard for the falsity. That's honestly about it. Like, you have to show what statement was false. And then the next part is how it damaged them. If you think back to all of Vic's petitions, they've all actually linked specific tweets or specific instances to damage as far as defamation goes. They called out tweets by Ron. They called out a tweet by Jamie. They called out a tweet by Funimation. And they linked those to Vic getting canceled from various conventions. Not to mention, they've talked about these. Some of these are per se defamatory, which if they're defamatory per se, that means that the damages element is presumed. And maybe even the malice element can be inferred / presumed from the, at least for the purposes of a prima facie case. Many of the people talking about this and what needs to be presented are still arguing on the basis that it's something bigger than prima facie showing. They're arguing about proof. Evidence proving this. You don't have to have evidence proving it. This court's going to talk about that in just a second. So here we go. Third, even if the plaintiff establishes a prima facie case, the defendant can still obtain a dismissal if he establishes by a preponderance of the evidence each essential element of a valid defense to the non-movement's claim. As we explained below, we conclude that Soleil filed a legal action that related to the right of free speech, and that right is defined by the TCPA. Thus, the act applies. Further conclude that Soleil failed to establish a prima facie case for each essential element of the cause of action it alleged. Thus, the third step involving proof of an affirmative defense does not come into play. Okay, so I'm not going to go through their thing applying the TCPA because the TCPA applies to just about everybody. Just about everybody and everything that they do. All right. So let's go to here. So this is the causes of action. And this is what I want to get to. Soleil relied on his petition as its sole proof to establish a prima facie case for defamation. Petition's allegations never identified the specific statements that it contends were defamatory. Thus, Soleil failed to offer the clear and specific evidence necessary to establish a prima facie case of defamation. Suffering from the combined strategic disadvantages of the wide net of the TCPA and the relatively low preponderance burden to show the act's application, a party facing a motion to dismiss often loses a first battle in TCPA dismissal war. But the non-movement can often rally back from that initial setback and prevail in the second battle of the war by offering the clear and specific evidence necessary to establish a prima facie case for each element of its claims. Here, Soleil marshaled minimal resources for the second battle and offered only its petition to satisfy its burden to establish prima facie proof. The TCPA allows a non-movement to rely on its pleadings to establish a prima facie case, but a party's choosing to rely only on its pleading gambles that the oftentimes conclusory and sketchy allegations of a notice pleading will not satisfy the clear and specific burden of establishing a prima facie case. Soleil took that gamble, and we hold that their gamble did not pay off. As we explained below, their pleading lacks the specificity necessary to establish what false statements were allegedly made by Rogers and RRK. All right? As set forth above, the second step of the TCPA dismissal process requires a plaintiff to establish by clear and specific evidence a prima facie case for each essential element. TCPA creates a unique situation in which a party's pleadings are considered as evidence that the trial court must rely on in determining whether to dismiss a legal action. In determining whether a legal action should be dismissed, the court shall consider the pleadings and supporting and opposing affidavits stating the facts on which liability or defense is based. No, I don't want that. Okay. Collecting cases standing for the proposition that pleadings are evidence for the purposes of TCPA. Though a pleading functions as evidence under the TCPA, that does not mean that a pleading that is sufficient to provide an opposing party with fair notice of the claim being made automatically makes that pleading sufficient to meet the clear and specific standard necessary to establish a prima facie case under the TCPA. So just because you provide adequate notice pleading doesn't mean that that's good enough at the outset. But again, importantly, this is about what is required. And this court is continually suggesting that the requirements for the prima facie showing are absurdly low. They're very low bars, okay? That even a well-drafted petition would by itself be enough if it was very thoroughly drafted. But we'll read about that in a second. Supreme Court dealt specifically with this distinction in the context of a TCPA motion to dismiss filed in a defamation case. This is Lipsky. Fair notice of a claim under our procedural rules thus may require something less than clear and specific evidence of each essential element of the claim, because the act requires more mere notice pleading, that is, general allegations that merely recite the elements of a cause of action, will not suffice. Instead, a plaintiff must provide enough detail to show the factual basis for its claim. In a defamation case that implicates the TCPA, pleadings and evidence that establish the facts of when, where, and what was said, defamatory nature of the statements, and how they damage the plaintiff should be sufficient to resist a TCPA motion to dismiss. The question here is, did they do that in the pleadings, in the affidavits, and in any other evidence, such as the, the attached depositions, deposition transcripts, the deposition, the deposition. My brain is broken. Oh my gosh. Hold on just a second. The appendices to the deposition. Oh my goodness. Thus, we must ask whether Soleil's petition provides enough detail to show the factual basis of its defamation claim. As we noted above, Soleil's petition quotes several of the posts that Roger made on ripoffreport.com and prefaces the quotations with the statement that the post contains several false statements. First quote contains 5 paragraphs and 525 words. In essence, the petition states that Rogers and RRK allegedly made false statements and that those statements were contained somewhere in the posts on ripoffreport.com, but the petition does not identify which statements are false. This failing renders the petition so conclusory that standing on its own, it does not provide the clear and specific evidence necessary to avoid dismissal. Such an allegation does not appear to even satisfy the rules of fair notice pleading. When a party predicates a defamation claim on a writing, traditional Texas pleading rules require the party to be specific about what statement was false, and the failure to do so makes the petition's allegation on defamation conclusory. In an action for libel, petition must set out the particular defamatory words, or at least their substance and meaning. Citing Murray versus Harris, nowhere in Kahn's petition does he inform the court of the libelous matter, nor does he set out the parts of the writing upon which the alleged libel is based. In short, we are left only with Kahn's opinions and conclusions as to the libelous matter. This is Kahn versus Biker Engineering Incorporated. And Davis versus Prosperity Bank, affirming no evidence summary judgment on defamation claim because of plaintiff's failure to identify specific defamatory statements in a police report relating to an arrest at a bank. If a pleading must describe the defamatory statements to be sufficient under notice pleading standard, we do not see how a pleading that fails to do so provides a clear and specific prima facie evidence needed to establish Soleil's prima facie case for defamation. By taking the approach of quoting swaths of Rogers and RRK's posts and stating that the posts contain false statements but never specifying which statements in the quotes are false, Soleil failed to carry that burden. Certainly the petition goes beyond a mere statement that defamatory statements were made, while not quoting any of the alleged defamer's words, but in significant ways, the petition is the functional equivalent of such an allegation because it never identifies which statements are allegedly false. Thus, we cannot determine whether the statements that Soleil contends are false are of only picayune significance or constitute defamatory statements because they, quote, tend to injure a living person's reputation and thereby expose the person to public hatred, contempt, or ridicule, or financial injury, or to impeach any person's honesty, integrity, virtue, or reputation. And without that information, Soleil cannot carry its burden of establishing a prima facie case by clear and specific evidence that Rogers and RRK committed defamation. As the Supreme Court held in Lipsky, the facts of when, where, and what was said, the defamatory nature of the statements, and how they damaged the plaintiff should be sufficient to resist a TCPA motion to dismiss. Because of the structure of Soleil's petition, we lack knowledge of what was said and the defamatory nature of the statements. Accordingly, we hold that the trial court erred by not dismissing Soleil's defamation claim. Now, I'm not going to go through the rest of this because I want to focus on the defamation here. These other ones are, business disparagement, tortious interference, and these are claims damage elements that we go to. And then sole issue of appeal is taken care of. Reading through these is going to get similar. Long story short, they didn't acknowledge any damage at all. And they didn't argue that the statements were defamatory per se, I don't believe, or damaging per se. And especially this business disparagement claim requires a specific showing of special damages to the plaintiff. Let's see. This claim, they construed this as tortious interference with prospective advantage. So they didn't follow that claim's damage element either. Here's where they cite Vanderlinden. Specifically dealt with the tortious interference with prospective business relations claim and applied to that claim the principle just outlined. General averments of damages will not carry a TCPA non-movement's burden of proof to establish a prima facie case. Here, Soleil put no more effort into its proof of damages for its tortious interference claim than it did for its disparagement claim. I guess we could take a quick look at it. No effort to meet this burden. Petition alleges its business disparagement claim in 5 paragraphs, each containing a single short sentence. The extent of Soleil's allegation of damages is that the appellant's actions resulted in damages, including special damages, in the amount to be determined at trial, but in no event less than $200,000. Okay, so this doesn't say how that happened. It just said their actions resulted in this. But it doesn't say where those damages come from. It doesn't say that it resulted in loss of business or they had to incur some sort of expense. It's just very, very sparse. But, yeah, so here is... here's the original petition. They actually have it here. Should we look at this thing? SCB has suffered irreparable injury because defendant published false statements about SCB's business. Defendants published the following on ripoffreport.com containing several false statements. Thereafter, they published this containing several false statements. What they should have done is argued that the gist of the whole publication was defamatory, rather than saying it contained several false statements. That might have been a better way to do that, because you can actually attack the gist of an entire publication. Subsequently, on or about November 11th, they published the following containing several false statements. All the above were published by being uploaded on the aforementioned website. In addition, the language of these is readily understood. The statements contained therein are capable of being objectively characterized as true or false, and the statements in the emails are being set forth by the defendants as facts. Plaintiff is in the business of financing services for clients around the world. In the business at the time the above statements were published. Language of these statements accuses the plaintiff of committing crimes and unlawful conduct. In addition, the statements who accuse plaintiff of immoral behavior. Many of the allegations contained in these publications are false. See, their vague language here is what's getting them on these. And the obvious intent of these emails is to injure or prejudice the reputation of plaintiff's business and constitutes libel per se. Plaintiff discovered the above statements by defendants. On or about August 13th, plaintiff caused to be served a cease and desist demand notice demanding that the above defamatory and false postings be taken down, indicating that the post would not be taken down. They continue to be published and available to the state. They should be required to retract their falsehoods and broadcast the truth. Defendant's conduct constitutes defamation. Negligently or maliciously publish false and defamatory statements of fact about plaintiff, a private company. Defendant's conduct constitutes defamation per se, and has suffered and continues to suffer damage to its business as a result. The amount should to be determined at trial, but in no event less than $200,000. Then business disparagement, TI, jury demand, prayer. So there you go. So that's it. That's all they put in their petition. If you remember Vic's petition, it involves specifically tying specific statements to specific dates, and then tying those dates to cancellations of the cancellations of the conventions. So, and if you also remember the other day, I went through where these alleged statements had been made, where they are shown in both either the plaintiff's filings or the defendant's filings. So yeah, according to that case, something more than what was presented in that petition we just read, which is very, very short, very, very sparse. Something more than that is required. But we know that from their statements that not too much is required. They seem to view it as a rather low bar. Simply show us something beyond the conclusory allegation of they defamed me. That they defamed me and it hurt my feelings is conclusory. That's it. But alleging that these statements were false and caused damage, the specific statements themselves, I honestly think Soleil might have had a chance to overcome that burden if they had merely stated that the entire publication, the gist of it, was false and defamatory, rather than saying several statements within the publication were false and defamatory. They would have had a better shot anyway, because then the court would be able to determine if the gist of the article was indeed defamatory. And they should lay out how the court determines what the gist of the article is. They should have maybe done that in an affidavit or in a brief, a response, in their response brief to the motion to dismiss under the TCPA. Well, they won that, but they should have put that in there for the appeals court. That would have probably been better for them if they say the overall publication contains enough falsity to make the overall reading of the publication, the gist of it, so to speak, to be false and to paint the company in a negative light. That's what you've got to do on those gist cases. We've talked about those in a different stream. Automata says that Connecticut law seems so patently overblown. Could you picture them throwing anyone ridiculing a religion in jail for 30 days? For example, the entire cast of the Book of Mormon? That's a yikes from me. Oh yeah, it's way overbroad, and there's no way that I'll have to look and see if that statute has been constitutionally challenged, but it seems very, very overbroad, and like it would sweep up tons of protected speech. Andre C says, correct me if I'm wrong, but did the citation to the Texas Rules of Civil Procedure about TCPA in that opinion state that the defendants can present affirmative defenses at TCPA? Yes. Yes. The defendants are allowed to present an affirmative defense, and if they, by preponderance of the evidence, show all elements of an affirmative defense, then the defendants will prevail even if the prima facie showing is made. So that will be assessed by the Court of Appeals as well, because their affirmative defenses are tucked into their TCPA motion to dismiss, right? And Lemoine tried to supplement them, although they'll have to argue whether or not the late filed ones count. But we'll see. And all right, that's what I have for you guys tonight. I'm about to read through some super chats. So that'll be fun. We'll read through these chats. I will I'm going to go on Twitch. Am I going to go on Twitch? I'm probably not going to go on Twitch tonight because I have an early appointment tomorrow. But I'll go on Twitch tomorrow, I believe. I might be qualifying for a new feature on Twitch. I don't know if you guys are interested in this. This is weird. This is weird. I might go on Twitch for like an hour or something. Anyway, yeah, I'll play something short. I'll play Dead Cells on Twitch. That's way shorter. This is a weird new feature that Twitch has said that I might qualify for, and that is a watch together feature where, as an Amazon Prime subscriber, I can watch Amazon Prime, a list of Amazon Prime shows and movies with my Amazon Prime subscribing audience or something like that. I don't know, but it might be an excuse for me to actually watch some TV, which I haven't done in probably 9 months. So that could be interesting. I don't know if you guys are interested in that, but that could be cool. I'll announce it when I actually have that. Maybe we can watch some anime or something together. I don't know what's on Amazon Prime right now, but it should be kind of fun. We can make fun of it, make fun of shows or enjoy them. Maybe Lady Rackets will watch a show with me for once. Let me teach you about anime. But I don't know what's on there. So it'll depend on what's on their approved list of Comrade movies, and we'll see. But I'm sure we can find something commie-like to watch. All right, let's read super chats, and I'll play the outro, and then we'll wrap up the stream for tonight. So if you do leave during the super chats, thanks for hanging out. I appreciate it. Check back tomorrow. I'll be putting together another show. I know I said I was supposed to release a weed video today. But that didn't happen for a whole bunch of reasons. So I'm sorry about that, but I'm working on it. I'm working on it. Okay. It's coming ASAP. Still getting into the habit of trying to release these short videos. I'm just not great at releasing the short videos. So, but the weed video is coming. Legalized versus decriminalized cannabis. There's a massive difference. It seems our politicians don't even know the difference. And I know really, really stupid people named Zach Viana don't know the difference. That guy's a complete moron. And, but I would like to explain it to people so they understand the difference between decriminalization and legalization, because it being decriminalized does not mean you have permission to use weed in the state. Despite the thought, oh, decriminalized means it's not criminal. No, it still really is. Still really criminal. But we're going to talk about that in the video, so you guys can check that out. And We need a weeb stream. Yeah, I need to do one of those. We'll work on that at some point here. All right, guys, let's read these chats and wrap up for the night. All right, Beige Devil says, hey, Nick, did Drexel ever tell you who the married woman that both of you know who wanted to start swinging, playing around in Clown World is? I know who it is. Yeah, I know who it is. So there you go. I don't know if he told me specifically, but I was able to infer very easily who that was. And I'm happy to report that I believe they have strayed far away from that Clown World, which is good. They should always stay away from that. Therapod Hunter says, Michelle Specht rocks that red hair a million times better than Marky does. Well, I mean, that's pretty true. Mario Carter 13 says, but like Michelle has gotten a big pass in this because Vic cheated on her or whatever. Michelle is not an innocent damsel. Let's just put it this way. Michelle is certainly not an innocent damsel. And Michelle playing on Vic's Christian guilt is not the, oh, I'm so hurt and offended by this sort of routine that lovely individual would like to put on. Michelle has her own demons, and she's very lucky no one has looked them up, I guess. 'Cause that chick is, whew. That chick is something else. So, yeah. It's interesting. You know, one party's reluctance to talk about things ends up making another party look better than they actually are. But try and remember that people are people. And typically relationships don't break down in a unilateral fashion. Typically, there's something going on in both of those. And the timing of that breakdown and the eventual end of that relationship, if that was the end of the relationship rather than it being a long time before, is very curious. So let's just ignore all of that, and let's just pretend that Michelle is not a rando thought and is definitely a good little victim. Let's just pretend that that's the case, and we can all put blinders on to the realities of human interaction. That's fine. Mario Carter 13 says, me suck lemonhead long time. Con sluts. The Dark Knight says, I'm Federal Agent Jack Bauer, and this is the longest day of my life. Bloodlines 8 says, Asterios is being sneaky. Is Dick overreacting? I don't know. One thing I saw between Dick and Asterios that made me very curious. I don't like this. There was a leaked chat log, and in that chat log, Asterios, who I assume knew the chat log would be leaked, said something like, don't show the chats though. It wouldn't be damaging to me, but it would be damaging to Dick. Right? Like that's this whole implication thing. Oh, it'll definitely be bad for someone. I'm not a big fan of that. I wish they weren't fighting. I like them both. But, you know, who knows? I don't know. I don't know what Asterios said about Dick or is alleged to have said about Dick. I don't know what Dick is supposed to have done that offended Asterios. I don't know the beef. What I do know is lawsuits cause lots of stress that break up all sorts of things. So, Slater Danger says, can I get a quick boost to 700 subs? Only 2 to go. So if you guys go subscribe to Slater Danger, if 2 of you are willing to eat that bullet, then you guys can pump him up to 700 subs. That'd be great. Angel of Death DXD says, hey people, could you guys do me a favor and help a broke college bro whose car just killed over? Thanks. GoFundMe URL /f/college-commuter-new car. Car. Dang it. College-commuter-new-car. So there you go. You can check out their GoFundMe there. The Gentleman Sausage says, breaking, Miley Cyrus inadvertently admits that everything Drexel said about lesbians is true. Oh, buddy, I'm going to be talking about that soon. Miley Cyrus just goes ahead and says that her... Well, I thought I had to be gay, but it turns out there's a great penis out there somewhere for me. That was good. Good job, Miley. Really helping the cause. Mario Carter 13 says, BRNE Workwear 1915, Bernie Work Camps 1917. The Dark Knight says, Dr. Katie, a woman that contributed 1% to the teamwork, got the credit for the man who actually made over 60% of the work. Women are victims and weak. Homestead says, Nick, BBC is BS, but Git comments does not equal actual work. I don't know anything about this. I'm assuming you're talking about the 850,000 lines of code. I don't know anything about it. I don't really care. I think I'm less concerned with who did the work and more concerned with how BBC constructed the narrative that ended up getting this chick trolled, and how her team rallied around her and saved her from the evil misogynists online. Hey, look, block, mute, don't look at your Twitter. Like, what? How did they? A couple people made a couple posts, and suddenly she was the most bullied person alive. Some nobody says, hit that like button, you goons. Sanburbia Pictures says, hey, Nick, get your spookies on by watching The Woods Bum, my independent horror short here on the YouTubes. Currently at 3,000 views, fight the good fight. So I guess check out The Woods Bum. I don't know what that is. I do not endorse this, but I encourage you to look it up, I guess. Isabel Caden says, hi, Nick, love you. Okay, bye. Hey, love you back. Thanks for stopping in and saying that. Travis the Bard says, oh wait, I read that one. Mario Carter 13 says, 0.26 of N-words explore black holes on film. Come on. Razgriz Reborn says, Nick, hear about Mass trying to ban the B word. Massachusetts trying to ban the B word. No. Sounds interesting. Spudnuck says, so will this case set legal precedent for the official cost of an N-Pass? $50 sounds worth it. Probably not. Probably not. I think this case will be dismissed. Ash Ukahime says, Connecticut sucked. That's the tip of the iceberg. Or sucks, not sucked. They actively suck, not past tense. Some nobody says, B, you're buffer than me. What you scared about? B word, you're buffer than me. What you scared about? My name is nobody says, figures. Urahara Kisuke says, racial discrimination is dead. Long live racial discrimination. Some nobody says, tell Ty to file it an hour early this time, FFS. Well, I hope they file it a day early. That'd be great. But I don't know. Not up to me. Justin Parrish says, the Office of Professional Journalism is attempting to trademark fake news and file a cease and desist against Trump. Good job. Good job, Office of Professional Journalism. I think Trump has arguably used fake news in commerce prior to the Office of Professional Journalism. It's also not particularly unique. And they would have, Fox News has been talking about fake news for a very long time. So several other journalistic publications, they're going to have a real trouble trademarking that phrase and then support and defending it. Jake CB says, are they citing Landry's only for the dollar amounts? No, I think they're citing, if they do that, they're really dumb. Because Landry's is obviously, as I discussed, Landry's is a much bigger company with many more resources than just a guy, even a wealthy individual. And there's no way that they would be citing that for the dollar amounts. I think they're genuinely citing it for the proposition they're putting forward. I just think it's not a great citation for it. Because there isn't. I'm not saying that there's a better citation for it. There's probably not a good citation for it at all. Half-assed Hero says, if you get deposed, I'll personally give you an N-word pass. Just use it when the time is right. Have you ever said it? Altria Mungara says, please go over the decision that bars TCPA in federal cases from the Fifth Circuit in the context of Meyer versus Wade. I should do that. That's an interesting one. Deathwish says, what's your opinion of R&R whiskey? I haven't had R&R whiskey. Rogue says it's a civil case. Vic Mignogna is not predator, no matter how much they screech. Lawsuit only happened because they kept going after him. Some nobody says, why are lawyers so freaking lazy so often? It's just sad. I don't know. I don't know. Freighter J says, did you say you had been served or hadn't? I have not. I have not been served. I've not been served anything by the other party at all. So there you go. Curious Items Inside says, who is your favorite Spartacus characters? Mine are Animaeus, Asher, Gannicus, and Alithia. Since I've heard you talk about the show Spartacus stream. Man, Gannicus. I just like Gannicus. I like Gannicus a lot. He's cool. And I like Crixus. I like Animaeus okay, but he wasn't my favorite. Gannicus and Crixus are great. Who is Alithia? Was she the wife of the whiny guy? I kind of liked Batiatus before that ends how it ends. That was good. I really liked Animaeus when he was down in the pits, man. That was awesome. He was a tough guy. So Finfrog says harassment can't be blocked, must be victim. Gunnar Renee Oy says Undone on Amazon is great. Bradley Mitchell says Funimation owns all things Robotech now. Please don't remind me. I'm furious. Furious about this injustice. Mad Black Man Lover Entertainment says I'm a thug who likes being naked and gay with men. Man. There you go. Okay. So the wife of the guy that imprisoned Spartacus. Is that Lucy Lawless? Or is it the or was it the blonde chick? The blonde chick who's the wife of like the prefect or whatever. All right, guys. I am going to wrap up the stream. Let's get some outro music. Whoa, that's loud. Sorry. Oh my goodness. So, join me over on Twitch in just a couple minutes, I suppose. I'm going to go grab a snack, go to the bathroom. Lucy Lawless. Yeah, I like her character pretty well. Great. So, come over and join me on Twitch for just a little bit. I'm not going to stream too long tonight because I do have something early tomorrow. But come hang out. I'm going to play some Dead Cells. Last time I played it, it was a disaster. So we'll see if I'm better at it now. And Super Saiyan for Trump says, truth is NBA had to grant ankles to survive jail. I think, do you mean grab ankles? We'll see. But anyway, yeah, come follow me on Twitch. Come hang out. We'll have a good time. And as for tonight, peace. Peace.
As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get on a new log. So pour out a glass for the tea, post on Twitter as we hear lawsplaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folk from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. who'd get unemployed. So pour out a glass for the tea, post on Twitter as we hear lawsplaining tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who's playing